Hello, everybody. Thank you for tuning in to the Liberty Report. With me today is co-host Daniel McAdams. And Daniel, good to see you.
Good morning, Dr. Paul.
Well, good. I'd like to visit today with the subject about the Supreme Court. We only have 8 justices on the court, and a lot of people are getting nervous about it. And of course, it's not political at all. This will take care of itself. But it's been 4 days, and it's been a lot of talk about it. A little bit of talk about the circumstances of Justice Scalia dying in Texas on a hunting trip. But there's a lot of talk there, and maybe that'll continue for a while. But we do know that both Republicans and Democrats are lining up now on who's going to replace him. And the big issue is when. So I find it rather fascinating that some Republicans will say to the the president shouldn't do this. He should not, nominate anybody. Wait out. He should wait for the American people to speak. But he has every right in the world to appoint somebody. He could do it today if he wanted to. At the same time, the Senate has the right to prolong the negotiations and the appointment. Certainly, the shoe was on the other foot when Burke was appointed, Bork, in the 1980s, I think. Yeah. And that went on, but that was Republican versus Democrat. So I guess you're really not surprised that there's a little bit of politicking going on right now, and we might visit about that and decide who we might appoint.
Well, as you point out, there's a rush to, there's a clash between whether he should, Obama has the right, of course he claims the right. The Senate, of course, claims the right to
delay.
Exactly, but I was reading an article earlier by Jonathan Turley. We'll talk about him a little later. Some of the things he's done, but he points out that of course the president has the right to do that. He thinks he possibly shouldn't, but he said the main issue is that the Senate has the right to advice and consent. Consent doesn't mean you have to consent. It means you have the option of consenting or not consenting.
Well, the bigger issue to me, and I think really for the country, because, people are disgusted with the way things are going, whether it's economic, foreign policy, and in the judiciary. I mean, the left, the courts are never liberal enough, and the right, it's not conservative enough. And some say, well, the only answer to this is for the two parties to come together and appoint a moderate. And I think that is an atrocious idea. And my point being that a moderate means that, we will concede that we have to give in to some of the mandates for economic intervention. And others will say, well, we have to concede to conservatives on social interventions. And it brings the worst out of people, which is contrary to what would it be like if you appointed a libertarian. Right now, there's a bigger question on whether the court's, on the right course and all this. But the thing of it is, immediately the appointment, why couldn't we make the argument that we would bring people together, which is always my argument about libertarianism, that if you have a libertarian, he's not going to satisfy everybody, all conservatives, all liberals. But he could satisfy the liberals by, maybe voting correctly on war issues and civil liberties issue, and satisfy the conservatives by voting right on economic issues. So why wouldn't this be a message that we could send, or they who are in charge send and say, this is the solution, this is the way we're going to bring people together? But that doesn't seem to be in the cards.
Bringing people together because you have an ideological view of things rather than that you'll compromise either way, however each case is decided.
Right, it's no compromise at all, and yet something, of course, has to be done. But overall, I think the big problem in this country is that all branches of government are polluted and distorted and unconstitutional, and they're out of control. But let's specifically talk about the Supreme Court. It's interesting that the court has gained so much power. I mean, when you think about it, they want to be the superior branch. And of course, we were forewarned a long time ago. And if anybody wants to study that, just go back and read Jefferson. Jefferson was really annoyed by this. So we got off on the wrong foot at the beginning. And everything he worried about, I believe, has come true.
You told, just before we started, you told us a story about when you first came back to Congress in '97, I think it was. I think that captures everything.
Yeah, I was very naive. I actually thought if you said Constitution, they would, oh, okay, what is the position on it? I was on the Education Committee, and they were doing some atrocious educational intervention at the federal level that they shouldn't be doing it. And it was sailing right through, and the Republicans were in charge of the committee. It was sailing right through, and I got my 5 minutes. I said, I'd like to question whether or not this is constitutional. So the chairman, the Republican chairman of the committee, he was very polite, and he says, well, yeah, I understand your concerns, but we really, I'll paraphrase, of course, we really don't have to worry about that because we can write the law, and if there's a problem with it, the courts will decide it. And I thought, well, why do we take this oath of office? Don't we have some responsibilities for this?
It reminds me of what they did with warfare, too. We can just pass it back to the president if he wants to go to war or not. We'll just give him a blanket authorization.
And it's a lot of not assuming responsibility. Your hands are clean. Yes, we're going to do good things by passing educational laws, or we'll say, yes, we're going to give the president authority to save the world by dropping bombs. But if he screws up, it's all his fault. And of course, I think that the courts are obviously way out of control. But the principle that I think that has been violated from the very beginning was judicial review. Marlboro versus Madison established the fact ever since that the ultimate judge and jury on whether or not a law can be passed and whether it's constitutional is always the Supreme Court. They can rule over all. And that has been very, very misused over the many centuries.
We had the opportunity a couple of times back when you were in Congress to have our friend Jonathan Turley, who we mentioned earlier, come and talk to the members that came to your special Thursday lunch group. And every time a Supreme Court issue would come up, we would try to get Professor Turley to come out and talk about it. And he had some really interesting ideas about the Supreme Court. We tend to think of it as it has always been this way. It's always been 9 judges doing a certain thing. And he came with some sort of radical reform ideas and reminded us that it hasn't been through history only 9 judges. It has fluctuated greatly throughout history.
Right. And his suggestion, of course, is to have 19 to sort of dilute the effect, because he resents, as well as a reasonable person should resent, is why should one single individual decide who the president's going to be, or other major thing, or whether the mandate of Obamacare is illegal under the law. So this is really a big problem, because it's very clear in the Constitution that legislation should be passed by the Congress. Most people still believe it, even though it's not true anymore. So the Congress is supposed to do this, but every branch now, I think the least legislative branch in the government now is the Congress, because you have the president just totally ignores them. They write all the regulations and they write executive orders and all these things. So the president's, in charge of writing all. But when it comes to the Supreme Court comes in and Marlboro versus Madison established the fact that they could declare a law written by the Congress to be constitutional or not, and the technicality there was the Judicial Act of 1789. They just said it was unconstitutional. So that was the principle that was established. But it's much worse now. Not only is every piece of legislation permitted to go to the Supreme Court, but it also starts legislating. You take Roe versus Wade. If you divorce Roe versus Wade away from the abortion issue itself and just look at the process, they ruled that abortion was legal for all the states and regulated. But then they got into the medical things. You could do this in the first trimester, second trimester. What do you do in the third trimester? And I thought, wow, this is so out of control. But if you take that principle and you can't look, and I say, well, they were well motivated and they were trying to protect life and this kind of thing. But the whole principle of the courts writing law, judging every other law, and one person literally is equal to 535 members of Congress, the House and the Senate. They pass these laws, and one guy, one vote, can make all the difference in the world.
And as Professor Turley pointed out in an article a couple of years ago, Sandra Day O'Connor was often the deciding vote. This is one unelected person who, as you point out, seems to have more power not only than Congress, than even the president himself, because the president does have to be elected and re-elected if that's the case.
Well, if, there was a time when I accepted, and it bothered me, well, if you didn't have a Supreme Court, who's going to make these decisions? Not realizing the people and the Congress can make this decision, the president and the people can make these decisions. When they get really out of hand, the people always should have a chance to do something about it. But there are certain things, the founders obviously thought there should be a Supreme Court or they wouldn't have had one. But if you look precisely to the Constitution for the federal laws that they might be involved in, the three major laws were treason and piracy and counterfeiting. But that's all been turned on its head. Of course, piracy is not the biggest issue of the day right now. Treason isn't a pressing thing, but the money issue is a pressing issue. In the Constitution explicit. So that's been to the Supreme Court many times, not many, but several times. And they've always ruled incorrectly. If they were if they were not paying off government bonds in gold, the courts ruled with the government. So it seems like what drives it is the lack of respect for the principle of limited government that was supposed to be protected by the Constitution. And then those who get in control, whether they're conservatives or liberal, they seem to want to enhance this power. And they never argue the case that what we want to do is reduce the influence of government on the people's rights.
Professor Turley included a very good quote from Justice Robert Jackson in 1953, and this goes to judicial review. He said, "We're not final because we're infallible. We're infallible only because we're final."
Yeah, there you go.
But he urged, if you remember in some of these lunches, he urged Congress stand up to the Supreme Court, pass a law saying what they ruled is illegal, is unconstitutional, overturn what they've done. He was trying to slap the congressman around a little bit.
Yeah, Congress has reneged because they can literally state those issues that explicitly should not go to the Supreme Court. Of course, if you read the Constitution, they shouldn't have gone anyway. They should have refused most of these cases that there's no jurisdiction. It's only in the very limited sense. I think bankruptcy is a federal problem. It's in the Constitution, but it is so limited. But the Congress could strictly say they'd limit the jurisdiction of the Supreme Court on certain issues. They've done it very, very rarely, but right now it's totally out of control.
It seems now with the situation in flux and people talking about the Supreme Court, it would be a great time to take a real look at serious reform. Unfortunately, I think the inertia has taken over to the point that these sorts of issues like Professor Turley has and others share probably won't rise to the surface.
Yeah, and of course his is to have 19, which would be better than 9. And it's interesting, most people don't realize they can do it just with a congressional law. You don't have a president's signature, I guess, too, but you don't have to. The Constitution doesn't limit, the number of people on the courts.
And I think his point is good that this reduces the importance of each single justice. It's almost like a personality cult, Scalia, the Ginsburg, the others, and if you had so many, it would reduce the importance of each one.
If you had more dilution, it would be good, and if you had more people, which is always the answer, more people who are honorable, understand the Constitution, a president that wouldn't abuse the Constitution, and a court that wouldn't do it. The biggest job they would have more members, and they could have more staff, and their big job is to sort it out, to make sure that they do not have jurisdiction. And they could get rid of 90% of what's going on up there because their economic issue, the two things that is really abused in the Constitution has been the Commerce Clause and the Necessary and Proper Clause, which is very, very vague. But a lot of times they'd write into the bill, they have a pretense, we justify this law by the Constitution. What's necessary and proper? But they have to get authority first. It's written at the end of Article 1, Section 8, emphasizing what the government, what they're authorized to do, and it's necessary and proper to do the job we gave you, is one thing. But if people don't understand that, but right now they say everything is interstate commerce. So it's absolutely totally out of control, and the people so far, the country's bankrupt. We're in a mess. People are angry. but they're still not looking in the right places for the right answers. They're searching and screaming. They want somebody who's firm and knows the answer and take charge, versus another people that what we need is more government ownership and more socialism. At the same time, the answer is here. There's no respect or understanding for the Constitution, but more than that, there's no apparent desire by the large majority to seek liberty over being taken care of. Though I think that we are making inroads there. It's just there's no influence in Washington, D.C. But I think the opportunity is coming, because the amount of laws, eventually this is going to break down. But one interim solution could be, even under today's circumstances, is to wake the people up to the ultimate resistance to bad government. And that is for the people to make a ruling themselves. And that is why they believe that a trial by jury was crucial. The English, the British believed it, we believed it, we put it in there, and it's supposed to be secret. You can never be tried twice, even though now they get around it by having state laws and federal laws and these things. But we should have state nullification, which is another thing that Jefferson supported. State to nullify laws that oppresses the states and forces them to do some mandates on the individuals, and also the jury nullification. If people knew that was instituted at the time, it was understood by the founders that certainly the juries have a right to know, what the law is and what they're not even allowed to know what the punishment is, and they don't know that they can rule on the law too. If the law is putting somebody away for life because he had a nonviolent drug charge, smoking marijuana, and they can't say, well, this is beyond the pale, we're not going to convict him. But they're not even allowed to know how long this person might end up in prison. So the judicial reform is necessary, but it's going to be much bigger than merely finding the right guy or right woman to put in here. And of course, for libertarians, the one name that readily comes to our mind is one judge that we know is Judge Napolitano would be fantastic. But can you think of anybody that we might use that isn't an attorney? A lot of people don't realize that you don't have to be an attorney. I think it'd be great to have a non-attorney.
That would be an interesting idea. I don't think it's crossed anyone's mind. I was going to mention Judge Napolitano would probably be President Paul's favorite.
Yeah, that's right. Anyway, I want to thank everybody for tuning in today to the Liberty Report. We obviously didn't solve the problem of who the next Supreme Court Justice will be, and we've emphasized the nature of the problem that we have today, because all branches of government are out of control. All are legislative in substance, and the worst legislative body is the Congress. Is supposed to have the control of writing legislation, but the Supreme Court is too powerful, out of control, and they shouldn't have judicial review. And Jefferson was right about this. It would lead to chaos. And the executive branch is every bit as guilty, because they write law just as well with all the regulations, all the things that they do. But the Congress is derelict. They're always delivering power to the executive branch, and they allow the Supreme Court to get away with this. And the Congress has authority to limit the jurisdiction, of the Supreme Court. So yes, it is true. Congress is derelict. They're all derelict. They all accept the idea of big government. But maybe the people have some responsibilities too. We don't live in total dictatorship. We just live in multiple mandates and a bit of chaos coming. But we still can speak out. So Congress does reflect the views of the people. Of course, we're in election season. We hear a lot of demagoguing. I wished I could hear more for the promotion of liberty and answering our so many problems with free markets and sound money and a non-interventionist foreign policy. I want to thank everybody for tuning in today to the Liberty Report, and please come back soon.